Connecticut is a solidly tenant-protective state, with a comprehensive habitability framework that landlords need to take seriously. The state's landlord-tenant law is found in Connecticut General Statutes Title 47A, and it provides detailed obligations that apply to every residential rental in the state. Under Section 47A-7, Connecticut landlords have a clearly defined set of duties. You must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. Specifically, that means keeping the structure in good repair and weather-tight, maintaining plumbing systems in working order with hot and cold running water, ensuring electrical systems are safe and adequate, providing heating facilities capable of maintaining a minimum of 65 degrees Fahrenheit from October 1st through May 31st. And many local codes set that minimum even higher, maintaining supplied air conditioning systems, providing working smoke and carbon monoxide detectors, keeping the property free from rodent and insect infestations, maintaining common areas in safe and sanitary condition, and providing adequate trash removal for buildings with more than 4 units. What sets Connecticut apart is the strength of its enforcement system. Connecticut has one of the most active code enforcement frameworks in the Northeast, and tenants have multiple avenues for addressing habitability issues. The first avenue is local code enforcement. Every municipality in Connecticut has a building department or housing code enforcement office that can inspect rental properties upon complaint. Local inspectors can issue orders to correct violations, and landlords who fail to comply face fines and potential legal action. In cities like Hartford, New Haven, Bridgeport, and Stamford, code enforcement is particularly active and conducts both complaint-driven and proactive inspections. The second avenue is the Connecticut Department of Public Health, which has authority over housing conditions that affect public health, including issues like lead paint, mold, and sanitation. The third, and perhaps most powerful avenue, is Connecticut's housing courts. Connecticut has a specialized housing session within its Superior Court that handles landlord-tenant disputes, including habitability complaints. These housing courts have judges who specialize in landlord-tenant law and are experienced in evaluating habitability claims. This specialization means that cases move more efficiently and judges are well informed about the nuances of housing law. Connecticut tenants have robust remedies when landlords fail to maintain habitable conditions. Under Section 47A-14H, tenants can petition the housing court to place their rent in escrow if the landlord fails to correct code violations after proper notice. The court holds the funds and can order repairs, reduce the rent, or apply the escrowed funds toward making the necessary corrections. Tenants can also pursue remedies under Section 47A-13, which allows them to file a complaint with the local code enforcement agency. If the agency finds violations and the landlord fails to correct them within a reasonable time, the tenant can seek a court order for compliance. In severe cases, the court can appoint a receiver to manage the property and make repairs at the landlord's expense. Connecticut also allows tenants to withhold rent in certain circumstances, though the process requires the tenant to follow proper procedures and the defect must materially affect habitability. The repair and deduct remedy is available for certain issues, though it must be exercised carefully and in compliance with statutory requirements. One area where Connecticut is particularly aggressive is lead paint. The state has some of the strictest lead paint regulations in the country under its Lead Poisoning Prevention and Control Act. Landlords of pre-1978 properties must comply with lead-safe housing requirements, and Connecticut requires that rental properties built before 1978 achieve specific lead-safe or lead-free certifications. Failure to comply can result in significant fines, and if a child suffers lead poisoning in a non-compliant property, the landlord faces serious liability, including potential criminal penalties in extreme cases. Connecticut's housing stock is among the oldest in the nation. Many rental properties were built in the early to mid-20th century, and some date back much further. This means landlords frequently deal with aging infrastructure, old wiring, outdated plumbing, deteriorating foundations, and the ever-present lead paint issue. Staying ahead of maintenance on these older properties requires consistent investment and attention. The state's climate adds another layer. Connecticut winters bring freezing temperatures, heavy snow, and ice storms. Heating system failures are treated as emergencies, and landlords are expected to respond immediately. The shoulder seasons bring moisture that can penetrate older buildings and create mold and water damage issues if not managed proactively. Connecticut's anti-retaliation protections under Section 47A20 are strong. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint about habitability, contacting code enforcement, organizing or joining a tenants union, or exercising any right under the landlord-tenant statute. The presumption of retaliation applies for 6 months after the tenant's protected activity, and a landlord found to have retaliated can be liable for damages and the tenant's attorney's fees. For the complete guide to Connecticut habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.